I rise to support the position of my colleague, the chairman of the committee, Senator Collins of Maine, in opposition to the amendment offered by the senator from Utah, which would inhibit, indeed prohibit, HUD from implementing or enforcing the affirmatively furthering fair housing regulations. I think it's important to remind everyone why these regulations were proposed in the first place. The Fair Housing Act of 1968 was enacted because banks, landlords, and developers were excluding people from buying or renting in certain neighborhoods based on race. Under that law, communities are required to take steps to further fair housing to prevent discrimination and segregation. I think we have come a long way from 1968, and I don't think anyone is arguing with the premise and the purpose and the beneficial aspects of that legislation. It's based on trying to ensure that Americans have fair access to housing, no matter their race in 1968, but we've added legislatively physical ability, family status, or religion. That people should have a chance to live based on their own choice and their resources, and that should be the deciding factor. And I hope we could all agree that people should not be turned away from a home and neighborhood because of their religion or disability or their race. And frankly, that was the aspiration in 1968, and still too often it's an aspiration in the United States. And what HUD is trying to do with these regulations is to give local communities the tools and the resources to live up to the legislative mandate that we impose and we continue to impose. And as the chairman said so well, this doesn't emanate from some person in a room thinking a great thought. In 2010, the Government Accounting Office did an audit to assess compliance with the Fair Housing Act. That's their job. They're the people who check whether federal agencies are doing what we tell them to do, we, the United States Congress. And they found that many HUD grantees did not analyze impediments to fair housing, that we were giving money to organizations throughout this country, and they weren't even making an attempt to analyze the impediments that existed to fair housing. They also found that for those who did, they failed to establish any goals or objectives to address any impediments to fair housing. They just found them and said, fine. That's not what the 68 legislation and subsequent legislation requires. And that HUD was unable to determine if a community was actually meeting its obligations under the law. HUD did not know whether the 1968 Act and subsequent amendments to that act by the United States Congress was being implemented at the local level. And this was the GAO's finding. They did the audit. And in response, and HUD is often criticized for not responding effectively to the GAO or anyone else, here they responded. They required and developed regulations which would insist that grantees conduct a fair housing analysis and submit their fair housing assessment to HUD for review. As a result of this proposed regulation, HUD went through a 2-year rulemaking process. This was not some whimsical, spur-of-the-moment decision, a press release to say, let's do this. 2 years, fully open to public hearings, comment, and review, fully susceptible to challenge in court if it was not measured up to the Administrative Procedure Act and to the Fair Housing Act of 1968. So this process has resulted in regulations that will actually carry out the intent of the United States Congress. And to reinforce and to clarify what the chairman has said, these regulations do not change existing law. They do not in any way dictate local zoning decisions. They, in fact, simplify the responsibilities of grantees to comply with the Fair Housing Act because they give the grantees the data and the tools to help communities comply with the law. And they do not require grantees to gather new data because HUD provides the data to them. And to help communities comply with the Fair Housing Act, HUD is working closely with the grantees, providing technical assistance and holding training sessions across the country. So this is a collaborative effort. It's an effort that does not dictate a national outcome. It helps localities working with their particular situation to develop a response to the legislative requirements that we have been emphatically insisting upon since 1968. And we're also working, as we should, to make sure that this process is continually evaluated by HUD to be streamlined, to be simplified, and particularly when it comes to dealing with small communities who can't bear the administrative overhead that some larger cities might be able to do. And HUD is providing assistance to ensure that these grantees are complying with the law. We all understand, and this is a principle that applies not just to HUD programs, but every program, that grantees have an obligation to use federal resources responsibly, consistent with the legal requirements. And basically, a requirement of the 68 Act was access to housing should not be denied because of race, and then as we further amended, disability and other categories. And this is the standard we should expect for all recipients of federal support, that they follow the law. This improved process, in my view, protects communities to ensure they still have a choice of how they meet their obligations under the Fair Housing Act. And there's nothing in these regulations that undermines the ability of a local community to determine these solutions. But they have to begin to recognize their responsibilities under the 1968 Act. And their solutions are ones that will be organic to the community. What works for them, given the objective of ensuring that there are no artificial impediments to access to housing. And it's also important to note that if HUD is prevented from implementing these regulations, that doesn't change the obligations of these communities under the Fair Housing Act. It's been in place for 48 years. Those requirements will still remain in place. And there'll be not only the opportunity, but there will be the obligation to take legal action in certain cases. Senator Kaine this morning was on the floor. And as a young lawyer in Richmond, Virginia, he became an expert in fair housing because people came with him with complaints, and he took them to court. What we're trying to do, interestingly enough, is avoid a lot of that by having a process where the impediments have been removed by a local solution. This amendment that Senator Lee proposes would prevent HUD from satisfying these GAO recommendations to provide guidance, clarity, and support to its guarantees. And this amendment makes guarantees liable for compliance without the tools or the data to do it. Ironically, it probably puts them in a worse position. And so I would join the chairman and urge all of our colleagues to reject this amendment.